मेनी है ना गैस में लगेन का है ना ये ट्रंक
Good evening, everyone, and welcome to third day of our workshop on alternative dispute resolution. Before starting with today's session, let me introduce today's speaker, Advocate Anubhav Jain. Advocate Anubhav Jain, sir, is a founding member of Nyaya Niti law firm, specializing in criminal and constitutional law, with a strong commitment to justice and an in-depth understanding of the legal landscape. He provides legal expertise, counsel, and representation to clients across all courts in Delhi. His extensive experience in handling complex litigation and high profile cases established him as a trusted legal professional in this industry. Early in his career, Advocate Anubhav Jain sir worked under the mentorship of senior advocates, where he gained invaluable insights into criminal defense, constitutional litigation, and strategic advocacy. With a strong foundation in litigation, he took a bold step and founded his own law firm 2 years ago, which has since grown into a reputable name in the legal fraternity. His ability to navigate intricate legal challenges has led him to successfully handle several landmark cases, earning the trust of clients and peers alike. In addition to his legal practice, he is a regular speaker at legal forums, webinars, and conferences where he shares his expertise on constitutional law, criminal law, and alternative dispute resolution in India. His passion for legal education and advocacy has made him a respected figure in the legal community. Beyond his professional accomplishments, Advocate Anubhav Jain is deeply committed to social cause. He actively contributes to NGO initiatives, conducting awareness programs for women's rights and empowering children with knowledge about their rights and responsibility in society. His dedication to public service reflects his belief that legal awareness is a powerful tool for social change. As a partner to one of Delhi's leading law firms, he remains steadfast in his mission to uphold justice, leaving no stone unturned in fighting for his clients' rights and ensuring that the principle of law and fairness prevail. So, without further ado, please join me in giving a warm welcome to our speaker, Advocate Anubhav Jain, sir. Welcome, sir.
Thank you, Karan, first of all, for the introduction, and welcome all to the third day of this session. So, today's session is about the ADR regarding mediation and conciliation. So, I will also not go into the theoretical part of the mediation and conciliation. I will be focusing more about the practical aspect of the same. So, many of you may be aware about the mediation process. Many of you may have attended the internship as well and have faced the mediation themselves in the court. So we'll be focusing firstly on the mediation, and secondly, after that, we will be having a look into the conciliation part. So first of all, uh, we understand mediations between two person. It should be necessary that there should be a two people again which are having trouble with each other, and they themselves agree to get into the mediation process. No one can force anyone to get into the mediation, and they have to agree that they want a mediator, or the court can instruct them if they are willing that they can enter into a mediation process. So the part in which the practical aspect of which we have seen in the court is the role of the mediator is not to dictate but to assist both the parties or n number of parties having trouble with each other. It can be regarding a matrimonial dispute, it can be a commercial dispute, it can be anything. So it is also not necessary to have a agreement beforehand in order to enter into the mediation process. You can simply ask the court that we both party want to settle this matter, and the court may send this case to the mediation. So there are very different types of mediation, as maybe you be aware about. So let me give you some of my experiences which I have faced and mediate as a mediator as well. So in a mediation process, there are many things. First of all, you need to know about the pre-litigation mediation. Nowadays, our government has made it mandatory for some cases, especially in the commercial case, to go to the mediation first and then litigate. Their motive is to reduce the litigation in the and the you see they can reduce the weight on the courts, that there are so much cases in the courts these days that the government want to reduce that, so they prefer to go to the mediation first. So in the commercial cases, the first step which you need to do is to sign a pre-litigation mediation form before filing any case. So in that sense, they will send a notice to the another party that the other party wants to file a case against you, and you have an option to go to the mediation first even before the litigation starts. So it is a proposal. It is not mandatory for everyone to. It is not mandatory to join that mediation by any other party. So after that process, if the person, second party against whom the person is trying to litigate, accept that, they go to the court. Before going to the court, they go to the mediation center. They if they agree on the certain terms and conditions, they can settle their matter right there, and they do not need to follow into the litigation. The basic purpose of ADR uh, is not to engage into litigation. You see, there are different process of ADRs. First of all, there can be arbitration, mediation, conciliation, lok adalat. Even lok adalat comes into these ADR process. The objective is to reduce the load of the court, and secondly, to help these people who do not want to enter the court. They can settle their matter outside the court through these process. So there can be different types of mediation, one of which I have already told as a pre-litigation mediation. Secondly, it is two things. There are two different types of mediation. First can be the national mediation, with the party lives within the jurisdiction of that court or mediation center, and their business could be there. And second can be international mediation as well. Our new act regarding the mediation, a new act regarding the mediation, which has passed recently in the year 2023, also assists the court to take the matter, not the court, to the mediation center to take the international matters if both the parties agree. So there can be different clauses, there can be anything, and the mediator role is not to dictate, but to assist these parties into coming into the settlement. He cannot force anything into these parties. They cannot dictate the terms to them. His role limits to the part that they do not engage into any conflict. His part is to assist and help these two parties to come into a mutual understanding and sign an MOU or anything, mediation agreement, anything. So in some these days, which I've seen, these days contracts also have this clause of mediation. You can have a clause of this mediation in the agreement, or you can have a separate agreement regarding the same. So it is important for these days to not litigate, but to mediate. So there are also the courts and the mediation center has provided this facility. I have attended many matters through my own office. I do not have to go to the particular place to attend these mediations. Online mediations are so common these days that people always try to neglect the litigation and say it's better that we attend these mediation. They are also available online. So it is good part of the ADR, and it is cost effective. As you see, the mediator will not, the court sometimes when send you to the mediation, they do not charge you. It is the cost of the government. So you don't have to pay anything to them. Whereas in some cases, when both the parties themselves decide to hire a mediator, they can hire them as well. But the agreement at the last is only depend upon both the parties to sign or not. Earlier, before 2023, I have in one of my case before 2023, there was one mediation agreement which was signed between the parties, and another party, when coming back to the court, said, "I do not want to follow this mediation agreement. I want to proceed with the litigation. He has already filed this mediation agreement. He has already said to the mediator that I want to get over with the case. But when he comes to the court, he said, no, I want to pursue this case. I do not want to follow this mediation agreement. So back in 2023, it was possible for them to negate these mediation agreements as well. But after the commencement of this new law, Mediation Act 2023, they have specifically mentioned in their clause that you have to follow this mediation agreement and you can be made liable if you not make any compliances with these agreements. So the basic idea of mediation is, first of all, is to not provide speciality like in which we see in the arbitration, but the mediation is for main objective is for the confidentiality of both the parties. You see, when you go to the court, you see people like Hardik Pandya and any other person who has come to the court, it becomes a news for the media. So going through this mediation process helps these persons to get the confidentiality of themselves and to protect their identity, as the law also states in the Mediation Act 2023 that you cannot record or videotape these mediation process. Moreover, it is so cost effective that people these days prefer mediation process. So secondly, when we talk about the conciliation part, conciliation is also an informal process in which one person sends invitation to the other person that if I want to conciliate this matter with you, and sending this invitation, when another person accept that conciliation invitation, only then this conciliation process can start. So the conciliation is not that much different from the mediation process, but it is also an informal process. It is also cost effective. It also, in this process, majorly when both of the parties state their case to the conciliator, and they hear both of them and they tell their other party story to the other person. And getting that thing from both the parties, they try to set an agreement for them. They do not, it is not like they will get back, they have to decide mutually. Rather, the conciliator decide after listening to their part of the stories that this should be the legal process through which you should go ahead. So in conciliation is that process. And he present the settlement process. So the mediation and conciliation are two different processes. In mediation, we see that both the parties should agree first, and they cannot be made complied with this process of mediation. But on the other hand, conciliation only starts when one person send invitation to the other person and say that I want to conciliate this matter with you. If you want to do so too, then we can conciliate. So in the mediation process, so both the advantages in both of these settings is that you have confidentiality. First of all, you cannot record you cannot record or videotape these conciliation proceedings as well. The mediation is more of a court process. There can be a court appointed mediators. There can be a separate body of mediators, and you can also appoint some mediator of your own. Whereas in the conciliation, no such authority has been given to the government to appoint a conciliator. It can only be done on the agreement of both the parties. So conciliation and mediation are these two things of the ADR which are booming these days. And as per the my experience, mediation is the should be made compulsory for every process, especially in the matrimonial process. These days, matrimonial cases have been on a rise. Every person having a dispute, as you can also tell by the CAW complaints which we see these days against the husbands. So by keeping these mediation process in check and by appreciating these mediation, the person having dispute do not have to go to the courts, as you can also tell by the Atul Subhash case when where there was a harassment on the part of wife to the husband. By the mediation process, these rigorous litigation can be reduced, and it can be done in every matter, every type of matter, whether you take international matters, whether you take commercial matters, whether you take any state related matters, whether you take any matrimonial, criminal, any matter can be solved. So in criminal cases these things get a little bit complicated, but on the other hand, if in the petty cases the mediation should be there, and that's why there are some cases which are compoundable as well. So what we see in mediation is that people are not being aggrieved of anything. They are usually having dispute with each other, and that's why they usually, when we go to the mediator, they say, इसने ये करा था इसलिए मैं ये कर रहा हूँ, इसने ये करा था इसलिए मैं ये कर रहा हूँ. So the mediator role is not just limited to solve these matters. His role is also to listen to both the parties and help them understand that it you should not take it as a personal vendetta against each other. You should be more thankful to each other and to the society. You should be having a conversation with each other more oftenly. As you know, in the commercial matters, it is more complicated rather than in the matrimonial cases. Matrimonial cases, usually the wife asks certain maintenance. The husband says, I don't earn that much. Then wife says he has this property. Then again, yes, Saloni, you want to ask something? Saloni, you want to ask something?
If you
You are not audible actually. Are you raising hand? Okay. Let's take these questions at the end of the session, if that's okay.
Yes, sir.
So, okay. So I was talking about the mediation of in a matrimonial case. So the role of the mediator is here is to let both the parties know that they have uh, they have life other than each other, and if they really want a divorce, they can still have a lot of life after these divorce. So in that case, the mediator usually call one person at a time at first and understand their story, and then try to make other person also understand that he's having such view and he's having such view, which makes it easier for them to understand that yes, there is something also something else going on in another person's life. So through these the mediation process in matrimonial cases are so good that I believe 50% of these cases are usually over in the mediation process only. When we come to the commercial courts, commercial mediation, usually people asking for itna percent interest and the foreclosure charges by the banks and some extra cost, whatever. The role of the mediator is to say there that person is having this much money. If you want to settle it, then you can go for it. Else, he does not have any property. He does not have any FD. He does not have any money left to pay you. So what can he do? So making them understand, and in these check bouncing cases as well, making people understand is the core of this mediation process. The mediator help people understand, and it can only be done after listening. When the one person, when both the parties are not ready to listen to each other, they try to listen to the mediator at least. So many of you must have attended some internships under some lawyer or something. You may have also attended mediation process. I know everyone would be having different experience regarding the same. Most of the times these things happens in peace, but sometimes things get out of hand as well. People fight in the mediation center, where these mediation centers are built in order to create peace between the parties. And the role of the mediator here is very important as well. So the mediation agreement once signed, it is binding on the both the parties, whereas it is made only after the agreement of both the parties. Whereas on the other hand, conciliation, when we talk about the conciliation part, conciliation usually is being dictated to the parties after listening to them, and amendment can be made to it as well, but usually it is not based on both the parties agreement, rather it is based on the law point, or majorly on the aspects of both the parties. By understanding aspects of both the parties, it is up to the parties in the end to sign it or not. It is not like the arbitration where there is a person appointed, and he take it as a case, and where both the parties present their case out of the court, obviously. So mediation and conciliation are not like that. It is much easier. It is not bounded by CPC as well, and not even by the Evidence Act. People may show their evidence, which whatever they have with them, to the mediator or conciliator, or it is not bound by the CPC. So other things can be taken into consideration as well, because in the end, both the parties are agreeing to it. So it is much easier and affordable. So you may have many questions. So let's start with the questions. Yes, Pushparna.
Sir, what is the difference between the arbitration and conciliation? I mean, there are two different terms. So, what is the basic difference between these two terms?
See, arbitration, when we talk about arbitration, arbitration is like a court process where the arbitrator has been appointed, and he takes up a case like a judge. The uh, the the decision he makes is his only. Like, he do not consult both the parties, and he cannot be told to amend these conditions of the agreement or something. It is not about the agreement. It is like a decision and can be enforced in court. Whereas on the other hand, conciliation is more about when both the parties decided to settle a matter, one of them invites the other person that let's finish this matter, and let's make a mutual MOU. Any other question?
No, sir.
Sir,
Harsh?
My question is, how is a mediator selected, and what qualification should he needs to have to be a mediator?
To be a mediator. To be a mediator, I'm assuming she's asking to
Yes,
be
sir.
a
Yes, sir.
mediator.
It's mediator.
Okay.
Yes, sir.
Okay. So mediator does not need to have any qualification per se, but according to the new act, when the mediation council, which has been established recently, he has to appear for a course in the mediation council. Other than that, any person can be a mediator in a process. It is not a formal process. It is more like an informal process because it does not necessarily be happening in a court only. Many you can see these mediation process around the country, not limited to the courts. So anybody can be a mediator.
Sir, can we say that mediation is more formal than conciliation?
Yes, we can say that. But both are same actually. Both are informal process per se, but we can say that the mediation is a more formal process because in some courts necessary make it necessary for the parties to attend the mediation, like pre-litigation mediation if we talk about. So it is more formal than the conciliation process, but yeah, both of them are informal only.
And sir, conciliation is enforceable or not?
If you have signed the conciliation, it is enforceable. But
But
if
sir, after when someone just say that I do not want to obey this conciliation after some time, then in such a situation, other party, what can he or she can do?
it depends upon where they have conciliated, they have created a MOU, they can ask for the specific relief for it. And if conciliation process is ultimately being done by the agreement of both the parties. In the end, both of them agrees to sign these conciliation agreements, and they have not been forced to sign these agreements at all. Other than that, if they claim that it is a fraud or they have been misrepresented or something like that, they can challenge it, of course.
Sir, in the sign of the conciliation mediation, there is there the jurisdiction clause in both
In the conciliation process,
in
yes,
conciliation and mediation both? Is
in mediation, there is a local jurisdiction, like the place of business, the place where the party lives, or the country where the party lives. In the conciliation, it is not per se limited to the jurisdiction part. Anyone can appoint anyone.
sir, in both the conciliation and mediation, there is a experience criteria for appointing someone for an conciliator or mediator. Like in the arbitrator, there must be a 10-year experience of an advocate, just Swam sir said in the last class. So
Hmm.
same thing
Hmm.
is happening in conciliation and mediation as well, or not?
No, not exactly. As I've already said, mediation and conciliation is an informal process. It is not necessarily be limited to someone's experience or someone being an advocate. Anyone can be a mediator or a conciliator. No such experience is needed unless he or she wants to get affiliated by the Mediation Council of India.
Thank you so much, sir.
Yes, Ankita.
Sir, like mediation is a little bit quasi judicial and they are not so much formal. So
Hmm.
it is the statement the people are making in mediation are not recorded. But
Right.
just hypothetically, if someone have said that XYZ statement and for the sake of they can't refuse it in the court, someone can record it as well. Like,
No, no, as I have said, these proceedings cannot be audio or video recorded. There is a restriction on that. Uh, as I've said, the confidentiality part, uh, they cannot record or videotape. And on the other hand, the mediator, if he sees that someone is making any defamatory statement or anything, he can send a report to the court that there was some mishappening or the defamatory words has been used. But he will also not tell the exact words and exact actions.
okay, so thank you.
I'm taking questions. I'm taking questions from the messages. Someone has asked, can you please, if there is a fraud and there exists an arbitration agreement, will it be arbitrable or not? Also, if addition to the fraud, these exist a right in realm of public policy objection in the case. Though in recent cases like Vidya Drolia and in Global SBI case, the arbitrary of fraud has been discussed in detail, but there is a big gap. Can you ponder on this little bit? I don't understand your question actually. Can you unmute and tell? Jatin, if you may. Okay, let's take another question for a meanwhile. Is ADR a true alternative to litigation or merely a complementary tool in the justice system? Obviously, ADR is a just a complementary tool. We cannot replace these litigation, the courts from the system and solely depend on the ADR. Because in the end, once we replace the codes from the ADR, the ADR system will collapse as well. We also need a codes in hand in order to get things done correctly. Because for arbitration, as Shubham has must have also told you, you have to, if there's an agreement of arbitration, you have to first reach out to the court to allow this arbitration. Once the court allow this arbitration, only then the arbitration can start. Niba, you want to ask something?
Yes, sir. Sir, if we
Thank you.
want to practice in arbitration and mediation conciliation, so as an practice advocate, fresher advocate, how much experience we needed for this? Like for this particular arbitration, if we want to practice.
For the arbitration, see, there are different council which make this procedure for arbitration. There are councils, there are mediation arbitration bodies through which you contact obviously and ask for the arbitrator. So there are separate different kinds of arbitrator. Some can be expensive because they have a lot of experience. Some can be little bit less expensive. They someone would be having a specialization in one field, another will be having another field. So in arbitration, there is no such aspect as experience. But usually, what I have seen through my experience, they usually have an experience of in their respective field, obviously, an experience of more than 10 years.
Okay, sir. Thank you.
Any more question? Someone has asked arbitrary arbitrability of the cases in which there exists serious fraud And what is serious in this? Also, if with fraud there exists a public policy and right in rem objections, if yes, how? Or should go in a criminal courts? So as far as I understand this question, he's asking if there is a criminal thing involved, can we go to the mediation or arbitration, right? So see, that's what I was saying. In these criminal cases, it become very complex uh, because some some cases are against the state as well. So it is not possible for every criminal case to reach the arbitration. I am talking about those petty commercial cases like fraud, like misappropriation of property, where maybe the intention was not there, and ultimately there it is a arbitrator decision to say not between it is not between the parties that they will decide, they will settle things between themselves. If that answer your question, Jatin. Harshvardhan, you have asked court order, or we can say refers to pre-litigation mediation most of the time. In divorce cases, until it has severe crime include. Am I right? No, not necessarily. Ultimately, no one can force you to go to the mediation. Uh, it is the choice of both the parties only. No one can force you to go to the mediation, whether it is in the commercial case or in the matrimonial case. Because in pre-litigation as well, as I have said, the it is the procedure of the court to send the pre-litigation mediation to the other party, but it is not necessary for that party to attend this pre-litigation mediation. Any other question? Ara, do you want to ask something? So someone has written arbitration award is appealable. Yes, it is appealable in High Court. Ara, do you want to ask something? You may write in call messages if you are unable to unmute yourself.
So there is a pre-conciliation, pre-arbitration, and other one is pre-mediation application is necessary for all the processes that I mentioned.
Sorry, what?
Sir, is the pre-mediation, pre-arbitration, and the pre-conciliation application process is formally necessary for all these processes?
No, pre-litigation uh, pre-litigation mediation is very much necessary for the commercial cases. Pre-litigation arbitration is only and only possible when there is an agreement between the parties that in case of any dispute, we will reach out to the arbitrator and not to the court. And for that also, as I have said, they have to reach out to the court only first to get it allowed. They can have a separate agreement for it as well. Someone has asked, sir, did court interfere between the arbitration process? No, not necessarily. Obviously, if the party have some dispute regarding influence over such arbitrator, They can always ask the court that such person is having influence or having some connection with the arbitrator, and he should be removed or should be changed. So please tell difference between mediation and conciliation. See, in mediation, both of them, first of all, is an informal process. In mediation, we the mediator only listen to both the parties and suggest the solution. Whereas in the conciliation, both the parties tell the conciliator their differences, their story, and conciliator decides in the end that what should be the agreement be between both of these parties. So if the arbitrator was biased, so what will happen in this process? So see, arbitrator, how do you explain that the arbitrator was biased? There should be something with you that tells you that he was biased. So if you know that he's having some influence or connection with other party, you can always approach the court with the evidence whichever you have, or you are having trouble with the arbitrator, you are having some dispute with the arbitrator, you can always ask the court or the arbitration council that you this arbitrator may be removed or changed. The relation amongst arbitration, mediation, and conciliation. See, these are all process which are done outside the court. The only relation which I see is to resolve the problem which is there, which may be solved by the court, but they do not want to get into the rigorous process of litigation and they want to settle it outside the court. So, what is more powerful, arbitration or mediation? See, by powerful, what do you mean by powerful? Like in arbitration, there is an award which is given by the arbitrator. In mediation, it is a agreement, settlement agreement between both the parties which they have mutually decided to settle in. So, what is powerful? Can a mediator give advice or do they have to remain neutral? Obviously, they can advise both the parties. They have to listen first and then advise both the parties that these should be your steps which you should be putting in your settlement agreement. The arbitration proceedings takes place in the arbitration tribunal. Where does mediation and conciliation happen? See, mediation can be done anywhere. Even the conciliation can be done anywhere. These days, when there is a already existing litigation court in the courts, the court instruct the parties to visit the mediation center which is present there. So, like the arbitrary process, arbitration process, it is not necessary to have a pre-existing place for it.
Sir, can you be just please more elaborated with this answer? Like, can mediation then happens? Can it be happen in a cafe also?
In a cafe, maybe it can happen in a cafe as well. Ultimately, the goal of the mediator is to provide you the space in which you both are comfortable and confidential as well. So in a cafe, maybe if both the parties agree, yeah, it can happen in a cafe
And
as well.
same goes with conciliation as well.
Right. Both of
Okay.
them are informal process. They can be done anywhere. It can happen in one person's house as well if both the parties agrees only.
Okay. Thank you so much, sir.
Sir, I have a question.
Yes.
Normally, we see when we take a loan in case like we take a vehicle loan, then we sign a agreement with the bank.
Hmm.
There and there is a clause in the agreement for arbitration. If any dispute is arises,
Hmm.
we will go for the arbitration.
Hmm.
And in such cases, what we see normally bank takes arbitrary award from the arbitration.
Hmm.
So in that case, can we move to the court civil and make a civil suit rather than going to the arbitration? Though I have signed the agreement that we will go to the arbitrator, but
Hmm.
still before going to the arbitration, can a customer go to the go for a civil suit?
See, if you have entered into an agreement where there's an arbitration clause, then you have to go to the arbitration first. It is only depending upon the bank as well if they do not have any problem going to the court before going to the arbitration, because you see, it is arbitration is a expensive process. So it is not necessary that they will go for the arbitration in every case. So it is possible.
And sir, in case if they get an arbitration award from the arbitration, so
Hmm.
can I challenge it to the civil court
In the High Court, you can. The
in the
appellate
high?
court for the arbitration for the arbitration what do you say, decree or judgment is in the High Court only.
Thank you, sir. Thank you.
Sir, recently, as someone was asking that mediation and conciliation can be happen in the cafe, the same thing can be apply for arbitration.
No, you see, arbitration is not an informal process. There should be a space provided, because you see, when the person is appointed as an arbitrator, he has the authority like a judge. He passed the order, he passed the judgment. So it should be in a formal setup only. But all these things can also happen online. So maybe everyone sitting at their home, arbitrator sitting in his office.
So, when proceeding is happening in the online, uh,
Mm.
there can be recording or not recording the
No,
proceedings.
no, there cannot be a recording of mediation and conciliation you're talking about.
I'm talking about the arbitration.
In arbitration, it depends on the parties. If they want, they can ask the court that we want to record the proceedings. They can, but they have to take the permission of the court, obviously.
But and sir, the cancellation and the other one.
It is not preferable. And as according to 2023 Act, it is not recommended to record audio tape or record these proceedings. The confidentiality part is important for all the ADR process.
So, sir, now in such a situation, how can we prove the conciliator or the mediator was biased in the decision making?
He is not taking the decision. The mediator and conciliator only present the settlement agreement which both the parties are agreeing to sign and to accept. He cannot be arbitrary. What happens if mediation is unsuccessful? Would the things discussed during the mediation be confidential? Yes, it would be confidential. The only report that the mediator will be sending to the court is that the mediation was unsuccessful, and he will not say anything about the proceedings, and he will not say anything about what the other these parties have communicated to them. It is a confidential process. Also, in mediation, if no settlement takes place between 120 days, the mediation stands cancelled. And the parties can ask for another 60 days in that matter, but not more than that. Do we need to file a petition for executing the award of mediation? You can, if the mediation process is final, you withdraw your case from the court and you say the other party is not following the settlement agreement. You can approach the court. Sometimes civil cases are make-upping as criminal case to avoid ADR by parties. Then what type of precautions activity done by other party advocate to avoid make-upping civil cases as a criminal case? I don't understand this question. Can you unmute yourself and ask?
Good evening, sir.
Good evening.
Sir, in sometimes matrimonial cases or property cases, civil cases,
Hmm.
in this cases, some advocates are creating the civil case as a criminal case, like the party was injured the other party, like that, and making us a criminal case to avoid ADR, approaching ADR. In that situation, what we can do, sir, for avoiding that? Civil cases or make upping as a criminal case to avoid ADR.
Okay, so you're asking how can we prevent ourselves or from making a civil case into a criminal case?
Yes, sir.
Maybe the intentions you have to show to the court that, like in the 420 cases these days, when there is a property builder, when they do not give their possession to uh, the tenants and to the people who have bought their flats, they usually file a 420 case against them. It is on the builder to prove that uh, my intention was not to misappropriate the property or to cheat these people. Ultimately, he has to show his intentions.
Okay, sir. Thank you, sir.
Is there any difference between mediator and conciliator in way of approaching, way to communicate to the person whom they have to mediate or conciliate? Uh, Whether you are asking how can we approach the mediator, then in this case, both the parties can together approach the mediator, whereas in conciliation, the one party has to send the invite to the other party uh, to come into the conciliation process. Like in arbitration, award is given. What given in mediation and conciliation? You see, in mediation, there's a settlement agreement between the parties, and in the same in the conciliation. In conciliation, the conciliator gives the settlement agreement to both the parties to sign after listening to their stories, whereas in mediation, it is usually an agreement between both the parties only. Any other question? Are mediators protected from liability if their actions lead to a failed settlement? No. How can they be liable for someone else's action? Their job is to uh, create a environment for both the parties to be comfortable to each other and to comfortable to them, so that they settle matters between them. If they do not want to settle the matter, how can the mediator be responsible for other person actions? If tape recording, etc., is not allowed in the spirit of the confidentiality, can the mediator take notes, reference point, and can it be admissible in court? He can take notes, but he cannot submit these notes and to the court. He will just say that the mediation has been failed and nothing else. in what matters conciliation process take place, and give me some example. In any process, conciliation can happen. Like in the mediation, like in conciliation, we say that it is an informal process first of all. Secondly, in conciliation, you say that this person, I feel this person has authority over both of us. So we can make him or her as a conciliator so that he can give us some guidance and he can give both of us something, and both of us will be beneficial from it. So in that sense, the conciliator has been appointed. Is there any difference between mediator and conciliator in way of approaching? I am asking that does the way of communication and style of approach to the matter are same to the mediator and conciliator? Yes, it is same. But in the mediation, both the parties uh, talk to each other as well. Whereas in the conciliation part, conciliator used to listen to both the parties separately as well. It is not necessary for both the parties to listen to each other as well. Any more questions?
Yes, sir. Can I ask in Hindi, sir?
हाँ, definitely go
हाँ
ahead.
सर, मेरे पास एक एग्जांपल है। तो एक मोबाइल फोन था जो कि 18,000 का खरीदा गया था। अभी उस पे 2 साल से इंटरेस्ट लग रहा था, जो का उसकी करंट जो वैल्यू हो गया वो 27,000 हो गया। अभी वो जो खरीदा गया था किसी थर्ड पार्टी के थ्रू, लोन के थ्रू लिया गया था। अभी अभी जो HDFC है वो उसका ब्याज ले रहा है, बेसिकली उसके ऊपर इंटरेस्ट ले रहा है। अभी अ, अभी क्योंकि बैंक में उसका इंटरेस्ट बढ़ता जा रहा है ऑटोमेटिकली, उसकी जो वैल्यू है उसके ऊपर, अमाउंट के ऊपर। तो अभी अगर मैं HDFC के वहाँ पे ऑफिस गया तो उन्होंने बोला कि आपका सेटलमेंट करा लो। तो उन्होंने बोला कि आप इसका इंटरेस्ट रहने देना, आपका जो अभी अमाउंट है ओरिजिनल उतना दे दो इंटरेस्ट को हटा के। अभी सर यहाँ पे ये इसे मैं कंसिलेशन में काउंट करूंगा, सेटलमेंट पे फिर मीडिएशन में?
Yeah, basically, this will come under mediation if the mediator was appointed. But as far as I can see, it was just a simple settlement and no mediation took place.
सर क्योंकि सर जो मतलब एक तरीके से जो लोन लिया गया था वो मेरी तरफ से, मतलब एक मैं और दूसरा HDFC था। तो एक थर्ड पर्सन आया और उसने बोला कि आप इतने के बरिए इतने दे सकते हैं, जिसमें उसका भी उसने एक पेपर भी साइन कराया कि अभी आपको इतना देना है और हम यहाँ पे सेटल हो रही है चीज पे। तो सर अभी इसमें कैसे डिफाइन करेंगे, क्योंकि उसने साइन भी करा लिया एग्रीमेंट, उसे कॉन्ट्रैक्ट बोल सकते हैं क्योंकि एनफोर्सेबल तो हो गया टर्म एंड कंडीशंस पे कि
But
ऐसा।
it is not necessarily a mediation, ना? For mediation, you need a person जो दोनों parties को सुन रहा हो. In this case, जो मुझे समझ आ रहा है कि सामने जो HDFC था, उन्होंने ही आपको अप्रोच करा and they said कि हम इतने में सेटल करने के लिए रेडी हैं। तो इसके अंदर मीडिएशन तो कहीं पे आया ही नहीं, मतलब आप दोनों पार्टीज अगर उसमें रेडी थे, आपने वो साइन कर लिया।
तो सर अगर इसमें अगर कहीं पे बाइसनेस लगता था, तो अगर इस केस में हम कोर्ट को अप्रोच कर सकते हैं, सेम थिंग?
तो आपने अगर सेटलमेंट कर लिया उसके साथ, आपने उन्होंने आपको बोला कि आप वो इतने में सेटल करने के लिए रेडी हैं।
हाँ, और
अगर
अगर
आपको
उसके बाद भी इंटरेस्ट अगर लग रहा है बैंक के थ्रू, अगर इंटरेस्ट आ रहा है फिर भी लगे जा रहा है, तो इस कंडीशन में तो कोर्ट का अप्रोच होगा क्योंकि हम
हाँ
साइन तो कर
बिल्कुल,
चुके हैं।
हाँ तो आप करोगे ना। आप अगर कह रहे हो कि अगर जो आपने साइन करा था एग्रीमेंट, अगर उस पे ये था कि आपका मैटर क्लोज हो जाएगा, आपको
Yes.
इंटरेस्ट फ्री, आपको जो भी देना था अमाउंट, प्रिंसिपल अमाउंट आपने दे दिया, उसके बाद भी अगर वो आपको चार्ज कर रहे हैं, तो आप खुद ही वो कॉन्ट्रैक्ट लेके जाओगे, जो एक कॉन्ट्रैक्ट है या एग्रीमेंट है कोर्ट के पास।
थैंक यू सर।
हाँ, इसमें मीडिएशन नहीं था, ये दोनों पार्टीज ने आपस में सेटल कर लिया मैटर।
तो सर ADR के अंदर काउंट होगा ये, मतलब अल्टरनेटिव डिस्प्यूट रेजोल्यूशन?
एडीआर एडीआर आपका, लेकिन यहाँ पे कोई डिस्प्यूट आया ही नहीं ना। जो आपका डिस्प्यूट था, आप उसको किसी के पास नहीं लेके गए, आप दोनों पार्टी ने आपस में सेटल कर लिया वो चीज। यहाँ पे आपको किसी थर्ड पर्सन के इंटरवेंशन की जरूरत नहीं पड़ी।
सर इसमें मैं कॉन्सेप्ट ही नहीं समझ रहा, क्योंकि फर्स्ट पर्सन मैं हूँ, सेकंड पर्सन बैंक है और थर्ड पर्सन उनका वो एम्प्लॉय है जो मेरे पास आया था।
तो वो अगर उनका एम्प्लॉय है तो वो उन्हीं की पार्ट पे है ना। उन्होंने बेसिकली आपको वो अपना जो भी डिस्प्यूट चल रहा था वो खत्म करना चाहते थे, तो उन्होंने अपना ही बंदा जो एचडीएफसी का बंदा था वो आपके पास भेजा, राइट।
यस।
हाँ, तो इसके अंदर उन्होंने मीडिएटर नहीं बिठाया कोई। मीडिएटर अगर इसमें कुछ होना होता, तो जैसे अगर आप कंप्लेंट फाइल करते कि ये मेरे पे हायर इंटरेस्ट रेट लगा रहे हैं, इतना नहीं बनता, इन केस आपने अगर ये ऐसा कुछ फाइल किया होता, फिर उनकी तरफ से पार्टी आती, वो अगर कोर्ट में बोलती कि हम कोई मीडिएशन में सेटल करने के लिए रेडी है केस, आप बोलते ठीक है। तो अगर आप दोनों के विदाउट कोई ऐसा इन्फ्लुएंशियल पर्सन नहीं था आपके उनमें दोनों में, तो मीडिएटर के पास भेजते, तो वो एक इन्फ्लुएंशियल बंदा आ गया आपके बीच में जो आपको दोनों को नहीं जानता या दोनों को जानता हो, लेकिन बायसनेस नहीं है कहीं पे भी। तो वो अगर आपका क्रिएट करता है कोई सेटलमेंट एग्रीमेंट आपसे डिस्कस करके करता है, तो वो मीडिएटर का रोल आ गया। अगर पार्टीज आपस में ही सेटल कर रही है तो उसका कुछ ऑल्टरनेट डिस्प्यूट रेजोल्यूशन का से रिलेटेड नहीं है वो बेसिकली।
सर इसे हम कंसिलेशन क्यों नहीं बोल रहे, मीडिएशन क्यों बोल
कंसिल
रहे?
नहीं, कंसिलिएशन भी कर सकते हो आप। कंसिलिएशन के लिए बस आपको पहले, जैसे अगर आप भेज रहे हो, अगर या पार्टी बैंक भेजता है आपको, तो वो आपको इनवाइट करेगा कंसिलिएशन में। आपको ऐसी अथॉरिटी, मतलब कोई ऐसा बंदा चाहिएगा जो आपका दोनों की अथॉरिटी पे हो, जो जो कंट्रोल कर सकता है आपको या हायर अथॉरिटी पे हो आपसे। कोर्ट कंसिलिएशन नहीं करवाता है, कोर्ट मीडिएशन कराता है। कंसिलिएशन आप खुद से भी कर सकते हो, मीडिएशन भी आप खुद से कर सकते हो, लेकिन कंसिलिएशन सिर्फ आप खुद से कर सकते हो।
तो कंसिलेशन से किसी थर्ड इंडिविजुअल का जरूरत नहीं होता, जो दो पार्टी जो डिस्प्यूट में है वो आपस में कर सकते हैं।
वो कंसिलिएशन नहीं होता। कंसिलिएशन में आपको थर्ड पार्टी चाहिए।
यस सर, थैंक यू सर।
तो ठीक है, किसी और के कोई क्वेश्चंस है, कोई पूछना चाहता है, वरना वी आर कंक्लूडिंग।
So can I ask something which is not exactly related to ATR but is of legal field?
श्योर श्योर,
As
गो
a
अहेड।
student, so majority people say me for taking part in moot court or debate competition or any kind of research paper, whether it is mandatorily necessary to do these things for a law student, or we must just focus on our academics to have good grades and internships as well.
See, your first focus should be on your practical aspects, and so internship first of all. But second of all, you should also do these moot courts. It helps you get more engaging. It helps you practice that how you will present yourself before the court, and it builds confidence in you. So you can do these things as well. It is not like you have to just focus on the theoretical part only.
Okay, thank you, sir.
Any other question?
सर मुझे अभी रिसेंटली एक इंटर्नशिप करना है एक एडवोकेट के अंदर, जो कि एजुकेशन की फील्ड में वर्क कर रहे हो फॉर माय कोर्स वर्क के लिए। तो सर कोई एडवोकेट सजेस्ट कर सकते हैं यहाँ पे आप, कोई फॉर्म जो कि एजुकेशन में वर्किंग हो?
इसके लिए तो आपको थोड़ा सा सर्च करना पड़ेगा। मैं ऐसे आपको रिकमेंड नहीं कर सकता, स्पेशली ऐसे सेशन में। तो आप एक बार थोड़ा सा रिसर्च वर्क कीजिए कि कौन से इस टाइम पे एडवोकेट है जो एजुकेशनल पर्पस के लिए काम कर रहा है। आप उनको डायरेक्टली मेल भी कीजिए, लेकिन मैं ऐसे सेशंस में ऐसे नाम नहीं ले सकता, सॉरी।
ओके सर।
Okay, last question. Arbitration, mediation, and conciliation. Who is the best to give decision? Whose decision are binding for a party? Arbitration, basically, if the settlement agreement has been signed, then all three of these are enforceable and binding on the party. But in the arbitration, they give the decision to you. You do not dictate your terms to them. So arbitration, according to this question, should be binding for a party. So any other question? So thank you guys for joining. Let's
Thank
hope
you so
you.
much, sir, for such an insightful session and engaging session.
Okay, I hope everyone learned something from this session.
Yes, sir. Thank you.
Okay, okay. Thank you.